Welcome to the program. This is Marty and Alan monthly show. Alan, say hello and anything you want to introduce our monthly webinar.
Hello, Marty, and hello, everyone. Thanks for making this happen.
So I got a whole long list of topics I've been thinking of, things that I've been seeing lately, or a couple unusual kind of concepts that we can talk about. I'd like to just take a minute. I don't want to do more because people don't love the fuzzy wuzzy topics, but I think one of the realities of estate planning, we deal with the frailties of human relationships all the time. And we all see, sadly, families disintegrate, over dad's pocket watch and other ridiculous things that become emotional battlefields. I'm not being political or commenting on anything, but um, I just want to take note that Jeff Metcalf was on TV, and there's an article written up about him speaking to Chris Cuomo about the tragedy between Carmelo Anthony and his son. And one of the things that he talked about is something that is got profound significance to estate planning. And he talked about forgiveness. He rooted it in his religion, but it doesn't need religion or any specific religion to learn the lesson. And he said some very profound things. Forgiveness is actually for me. It allows me not to carry around hate, anger, rage, revenge, any of that. It'll eat you like a cancer if you let it dwell inside of you. And it goes on. But you know, I don't know what role we as estate planners can play, and you may choose to comment or not, Alan, but if we all see these trite fights over, mom loved you more, or you got the better costume for Halloween. I mean, really irrelevant stuff that just destroys families. I don't know that we can have a forgiveness conversation, but boy, would that go a long way to mitigating a lot of pain. Any thoughts or comments, Alan?
Well, we can have a big influence in the conference room or on a phone call as to whether a client may decide to get irate and start spending legal fees on litigation, or whether a client can just tone it down and understand that the other side is emotional, the other side has issues, the other side is imbalanced. Give them a benefit of a doubt. Let's talk about it, cool down. But if the client goes to a litigator and the litigator starts sticking pins in it, then you can cause a lot of dysfunction and problems in families. So I think
Irreparable harm often.
irreparable harm. And as an estate planner, as somebody who's kind of neutral and logical, you can just, you know, throw some water on it and try not to let all this emotional violence happen. You don't, it's not your brother, it's your sister-in-law. Let's still love your brother. The sister-in-law made him do it. Let's just relax. It's not worth spending all that money on legal fees, and then you'll never see your nephews and nieces. Let's try to be the adults in the room. Listen to them again, keep listening to them. The more times they tell the story, the better it is. And hopefully you'll diffuse that bomb.
I often talk about the Thanksgiving test. Can you just handle this in a way so the family can still sit around the table and eat tofurkey together?
Right.
You know what tofurkey is?
No, what is that?
Oh, shame on you. It's a tofu turkey because we don't eat meat.
Oh, okay.
So you want to be able to sit around and eat tofurkey together. Um, I, 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 I don't want to belabor it because I know people like more technical stuff, but this is really a vital role to play. There's way too much hardship and angst and pain in the world already, and if we can minimize it for families, especially when it's you know petty stuff that is just because of the heat of the moment, the emotions, we should certainly try. Alan, let me talk to you about a topic that I know you've seen a million times and I've seen a million times, and that is the sale continuum. So a client is here with a business that's growing, and if they come to us, we tell them, let's do estate planning. No, 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 though. Until they have a done deal, or get very, very close to the done deal, they don't want to go through the estate planning because what if the deal doesn't go through? So there's a continuum, nothing going on, done deal. And too often they come to us when they're here. It'd be great if they came here, and even better if they came here. How do you and I didn't prepare cases and citations, but I think this is an important role for all the advisors to play because whether it's the accountant, the insurance consultant, the wealth advisor, when the business is here and there's a possible sale down in the future, get them here to talk to the estate planner, not here. Any comments or thoughts on that?
Just the power of persuasion and education. Floyd, if we don't do something now, you're going to be bigger than we can handle. If we don't get this in a charitable remainder trust well before you have a serious letter of intent, it may not work. You have to let us do this. It's just make sure you put that, I guess, in writing after the meeting. I strongly advised you to get with me well before the business explodes in value because a lot of times the entrepreneur will tell you this thing's going to explode in value, and they're absolutely right. And sometimes you have to plead, talk to their spouse, talk to their CPA, beg them, yell at them, whatever it takes. Let's get real.
One of the things that worries me with this, email is ubiquitous. And if those emails are discovered and the client's been emailing the investment banker about the sale of the company and now comes to you and says nothing's going on, that's problematic. Um, I have one of these transactions in process now, and I've actually been calling all the advisors saying, listen, once there starts to be documentation of a sale, that becomes problematic. Right now, today, nothing has happened. Nothing has been signed. Nobody's been retained. There are no identifiable buyers. So, but I'm trying to hold the dam up because I just know what happens when people start talking and whatever. One of the issues, and this is not a criticism of the investment bankers involved, but their goal is to sell a business, and they're going to get gung ho to do that, and they're going to want to push it as fast as they can, and they're going to want to laud what they can do to sell the business to the client. All those communications become worrisome, and sometimes you kind of just have to hold them off while you complete the planning. Um, Again, something that again all the advisors should be monitoring this and talking to clients about. It's so much easier to do stuff ahead of time, so much easier. um, I have an interesting transaction, and we may have talked about it, but I've gone further with it, and I just want to talk to you about it, Alan, and bounce it off of you for your thoughts. And I think it's an interesting demonstration that planning is about people, not just the highly technical stuff, and how we as planners can take common tools and techniques and apply them creatively for um, unique circumstances. And I don't think this circumstance, even though I've never seen it come up before, I don't think it's that unique. So um, the particular individual is a grandson of a client, and the grandson inherited money from, I don't know, aunts, uncles. Somebody left them like a $500,000. And of course, they never listened to Jonathan Blotmacher, where everything has to be in trust. And what did they do? They left a $500,000 outright. The, this grandson has both drug and gambling addiction issues. The $500,000 was really exacerbating the problems. We were able to get a mental health professional in to start counseling and talking to the grandson. And he was actually not only receptive after some period of time, but quite insightful. And he made a comment that'll lead up to what the planning suggestion of what I'm pursuing. And this is everyone, non-rehearsed. So Alan may say it's stupid what I'm going to propose, but we'll hear what he has to say. The grandson was actually very insightful and said to the therapist, listen, I have impulse control issues. When I get all excited I'm out with a group of friends, It's hard not to walk into a casino and now you can do it all on your phone. You don't have to go anywhere. So it's hard to resist. And he asked the therapist, is there something that I can do that will create some hurdles? Not that I want to be able to get to my money, I want to control my money, but I want to have impulse control. I want something to put a brake on me before I can go out and spend, especially large sums of money. And just by way of illustration, 100 grand was burned through pretty quickly. And I think we've been able to educate the grandson so that he understands that this is, 400 grand is a nice chunk of money to preserve and protect his future and give him a leg up on life. And more money is going to be coming from grandma, but we obviously want to get these lessons learned, if you will, with this first chunk of money and make sure he is not harmed by it. So what I proposed was the following: for 400 grand, and what the therapist and we've been doing a lot about financial education, which is a really under-addressed topic. Too many heirs are just not prepared and don't understand even basic budgeting or investing before they get money, which is another reason everything should be in trust. But what the plan is we're going to put 300 and change into a structure I'm going to explain, and 100 grand is going to be in an account where he's going to get a stipend based on a budget, a monthly stipend into his checking account and with cash card access so he can live. And he's going to try to live on that. And the plan is to defer any spending of the approximately 300 and change for 4 years and to use the 100 and change to support his lifestyle for the next 4 years. So what did I do? What did I suggest? I can't really do any kind of irrevocable trust because he's going to want his money, and doing a self-settled trust for 300 grand or so it just doesn't make any sense cost effectively. And I know if Jonathan Blotmacher were here, he'd say you can draft a DAT for 15 minutes of time in ILS, maybe it's an hour, but it's still too costly, the trustee fees, everything else. So any kind of irrevocable trust just seemed out of touch in terms of practicality and cost. What I suggest is we set up a revocable trust because that's cheap and simple to do, and you don't have to pay a trustee. And what I am trying to do, and we're still pondering all this, is create structures in the revocable trust to give him, the grandson, the impulse control that he's asking for, but not wrench total control ultimately away from him. And I found a couple of um, uh, 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 common rev trust arrangements that we can do that with. So the first and obvious one is trustee. So I offered, do you want to be a trustee? Do you want to be a co-trustee? Do you want to name somebody independent as a trustee? And we discussed it. He understood the concepts. And I think the whole process of discussing this has been empowering for him because he's feeling like he's really involved in the decision making, which itself is great. He opted to have a co-trustee and to require that there be unanimous consent for any decisions. And then I said, we got to mandate that there can be no cash card given on any of the trust accounts because if you have a cash card, the impulse control is gone. There's no one to serve as a break. It's got to be only written checks, no other types. And I'm not quite sure how physically, mechanically that gets implemented with the bank, but we'll have to figure that out. But we're going to at least provide for that. So one level of impulse control is to have a co-trustee. Second, and maybe you have some comments or thoughts, I want to have a trust protector. And I explained to him, listen, trust protectors, one of the common powers is to remove and replace a trustee. I think that if you're really in bad shape or you have, something goes wrong, you should permit this trust protector to even remove you. And he was agreeable to that. What other powers, and then I have a third one I'm going to come to, what other powers might you give a trust protector in a structure like that?
Well, I like the fact that, well, isn't it really an irrevocable trust to some extent if the trust protector can prevent the grantor from controlling it?
Um, at this stage, it's just the removal. It's an interesting question. Um, for this small size and the fact that the money is going to be spent, I'm not going to file a gift tax return. I don't think that's even in the realm here. Um, it's an interesting question to ponder, but right now, what we were contemplating is the trust protector could remove even the grandson as a co-trustee, but that's only going to happen if there's really bad stuff going on. And I would imagine that the idea would be that if there's a relapse and he's not doing well, you remove the trustee role and then you give it back later.
Yeah, that can work. That can work. And there's somebody in his life that he feels comfortable having as trust protector, like an uncle or a
Yeah, there's
something
some
like
friends and family. The third component to this, and this is something that I've seen used very infrequently, and honestly, it's probably important for all of us to consider more often than not. Revocable trusts are not just about avoiding probate, they're about protecting people from elder financial abuse. And that is, to say the least, epidemic in our country. And nobody will ever know what it is because so often it's done by friends and family members and it's not even reported. But one of the powers I've seen given is before you can modify or revoke the trust, you need the consent of a non-adverse party, the lawyer, the accountant, somebody that's been a family advisor for a long time. And the reason for that, and I've sadly seen this where the home health aide or the bad child who's like involved takes an elderly parent to some new lawyer. And shame on these lawyers that do this, and they revise a new will, new revocable trust, naming the caregiver, the one child, the home health aide is the primary beneficiary. I mean, I don't know how people can possibly think that they're not going to end up getting in the soup with that, but I've seen it happen. So I like the mechanism of having a non-adverse party, the attorney, the accountant, a professional with a license that's not going to act irrationally, approve it. So those are the three mechanisms that I thought of building in. And in year four, the plan is that if this grandson is now holding a job and saving money, that we can even dismantle the whole thing. And, they should be by then much more knowledgeable about dealing with finances and so on and so forth. Any thoughts or comments?
I like it. I think it's a nice plan. What may just work best is the fact that there's peer pressure. He's got a friend and an uncle and a lawyer who he's become friendly with, and you're all watching and cheering him on.
In a
It
positive way.
right. For a
Yeah.
lot of elderly clients or infirm clients, our revocable trusts are only revocable with consent of one or more individuals named in the trust agreement, or the way I draft it, they have to get two specialty doctors, neurologists or psychiatrists, to sign off on any amendment. So it's harder to pick their pocket, but that would work very well for this young man. That he,
Have you had problems with the physicians being willing to sign off or be involved in that
no,
way?
no, there's a lot of really good neurologists, at least in our city. We have a lot of good neurologists who are willing to sit there and meet with somebody and even be there when a client signs documents and say, I just spent 45 minutes with Mrs. Jones, gave her a memory test, discussed everything, and I'll witness the document as part and write a letter that she seems to have all her marbles. She's able to do this.
Yeah, I like that mechanism. I don't find it in very many trusts at all prepared by others. We've used it. I don't know if sparingly is the right word. I like using it because of exactly what we've just discussed. I think it behooves a lot of practitioners to think about it because the elder abuse situations are just bad and growing.
Right, right. You know, Marty, the life insurance industry has annuities that just get you give the life insurance company the money, and they'll give you the money back, so much a year for the next X years with interest. And, so if it's only 100,000 and there's you really can't even afford a lawyer, call a life insurance company and just say, I want a deferred annuity and I'll send you 100,000, send me back 20,000 a year with interest for the next 5 years. And once you've done that, it's really hard to get you your money back faster. You'd have to go sell it to a pawn shop, to a pawn artist, and get a court order. So that's
We
another.
we've actually seen non-cancelable annuities, and we've done that in instances just like you're describing. For example, we have an heir. Aunt Nellie wants to give little Joey $250,000. I could set up a trust for $250,000, and the hassle of dealing with it, is it really worth it? And instead, we've had on death a not the executor directed to buy a non-cancelable annuity, and sometimes we put in the parameters. So little Joey is going to get a check, every quarter or sometimes every year if it's small like that for X years, if it's a big enough number for life. But that kind of takes the whole complexity out of it, and it provides some safety net because every quarter or year, it's not going to be monthly at that dollar size. There's going to be a payment made, and you can't spend what you haven't gotten. So that's a great tool too. And that's why
Right.
when I hear these, I've seen abuses with annuities. I had a client not too many years ago where somebody had hustled her on annuities from a well-known institution and put like 70-80% of her wealth into an annuity, like almost everything but her house. And suffice to say, I introduced her to a litigator and they addressed it. But annuities in the context that you just mentioned, I think, is a phenomenal tool for the right circumstances. And I think that's kind of the take-home point from a lot of our discussion so far today. And that's that, like, this special application of a revocable trust, the discrete and appropriate use of annuities in certain arrangements, these mechanisms to prevent abuse. That's where I think the art of our profession comes in, because anybody can slap together a form, but it often doesn't take a lot of tailoring to make that form really unique and work well for the client's specific circumstances. Um, Let me change gears completely. We got to do something more technical so the people that like love talking about GST exemption at July 4th barbecues um, will have something technical. So there was a recent PLR. I'm not going to go through all the facts, but I think it's a great point to remind everybody that this issue is out there. And the PLR is 2026 22001. 2026 22001. And it was about the investment company tax under Code Section 721. And just in brief, what happens if you have a flip, an LLC, a flick, a family limited partnership, you have an FLP or LLC, and a whole bunch of family members and trusts and people all contribute securities to it. If you end up diversifying the portfolio from what people had, you trigger a tax under the investment company rules under Code Section 351. It's really important. This is not diversification as your financial advisor or wealth manager defines. This is diversification mathematically, mechanically, exactly as the code section says. So the only way to know this is to do an analysis applying the code section rules and see if in fact, oh my, we're violating it. I think a lot of people are not aware of the rule or forget about the rule because it doesn't come up that often. But in estate planning, it's very common, not just for discounts, but certainly for asset protection planning, having control over younger children or other heirs' money by having it contributed to an FLP, and you can't do it with a minor. That's another discussion. You got to make sure you go through the mechanical test, because if you trigger it, you got an immediate tax cost. In the PLR I just cited, they concluded that the contribution of assets didn't result in diversification under the regs under 351. I'll give you the site if somebody wants. 351-1, little c in parens, 1I, all in parens. It sufficed not to trigger the rule, but you gotta make sure you test for this. Alan, any comments or thoughts on it? Then I have a couple of comments on how to deal with it if you go, oh my, we messed up.
Right. So in other words, if I have IBM stock and my brother has ATT stock and we put it in a partnership and we each own 50% of the partnership, I'm considered to have sold my stock to him and he's considered to have sold his stock to me. We have a provision in our operating agreements and partnership agreements that say that any contribution that would trigger that. I think it's under section 721B that then refers to the 351 regs, causes a special allocation to apply. So if I put in my IBM stock, he puts in his ATT stock, my IBM stock is allocated to me only. His ATT stock is allocated to him, and hopefully we don't trigger that. But otherwise, you do have to read those interesting regulations and
Interesting.
sure that when clients diversify, they don't trigger that.
So I think that's a clever point to have something in the agreement. I would suggest to colleagues, if you can, better to be proactive and test for it rather than have to fight with the IRS about a provision in an agreement. So there's a couple of ways that you may deal with it. What Alan just said is one. I'm a concerned because often people don't sign an operating agreement or partnership agreement until after the fact. And will the IRS respect a special allocation that was put in place 6 months later when somebody realized, oh my, we have a problem? I'm not saying they shouldn't because it's still an agreement and that's what your agreement is, but it may be a little more nettlesome to win that argument. You may have another option. There's a provision where you can opt out of Subchapter K, opt out of partnership taxation. So if you opt out, it's really as if each individual is taxed on their own and there is no partnership tax. And that is under the law permitted after the fact. And then there's another concept, which we've talked about, Alan, and I know with Jonathan many times on when different tax law changes are pending, of rescission. It may be possible to rescind the transaction because it's clearly not what was desired. The problem with rescission, you obviously intended to do the partnership. What basis for rescission is there other than saving taxes? So that may not fly, but if you know if all else fails, maybe you go for that.
How does rescission work, Marty? You have to prove that there was a mistake, and you have to do it in the calendar year that the transaction occurred.
That is a critical point. The last point you made, it must be done in the same calendar year. And the reality is that if nobody was aware of the 351 investment company rule issue up front, the 721 investment company issue up front, it may be discovered by the CPA when they're doing the tax return. But I have found most CPAs aren't familiar with this because it's just not something that comes up very often. But if you find out in the following year, you now have lost out on doing rescission. The issue with rescission, and I just can't quote the ruling in the case by name. There's some solid law on it, but in I think it was the ruling or the case, the transaction had presumed, and I believe I have this right, that there was going to be a zoning change on some property, and because the zoning change couldn't be obtained, they rescinded the transaction. That was a non-tax reason that was external that went to the heart of what the deal was. So that's probably not going to apply in your typical securities flip or securities LLC. So I like the idea of including from the get-go the provision Alan said. The best thing to do is to test it up front. All else fails, sign the agreement effective back as the date of it being done. Do not backdate, date it the date it was done. Opt out of Subchapter K and evaluate rescission, even if it's tenuous, it may be the only approach you have.
What happens when you opt out of Subchapter K and my brother and I own this LLC together? Is it just considered to be, it can't be a co-tenancy because then we would be considered to have sold to each other. So how does that work?
I think if you opt out of Subchapter K, it's as if you are reporting your own income directly from what would have been the partnership entity, and your brother would report his share of the income directly. In order to opt out, you have to be able to calculate income without the partnership. So if you had a rental property that's in a partnership, opting out, can you each calculate your gain, your income for the year? With securities, going back to your example, and just to make this a little more updated, you have SpaceX and I have whatever from one of the new AI issues. You would report your gain and loss, and I'd report mine.
Okay, that's good to know.
That's my understanding of it. I don't I know I've done it, but it's been decades ago. but I believe one of the requirements to opt out is you have to be able to calculate gain or loss on your own. Um, let's change gears and let me ask you a question. I've not seen this done, and it was just recently proposed for a client, and I'm pondering it. So, mom has a business, and one of the daughters is active in the business, and mom wants to give, and I'm not sure who recommended this, so I can't, I'm just not sure, but I've just not seen. Mom wants to give the daughter a profits interest in the business. And she wants to do that to reward the daughter for all the valuable contributions daughter has made to the business. What are your thoughts on that? Any thoughts or ideas?
Well, if she gives her a waterfall interest where the daughter's only entitled to income from the increase of income going forward, then the daughter doesn't have to pay income tax on the receipt of that profits interest. That goes back to the old diamond case. And then the daughter's rewarded for sticking around with the business and making it go well. You've got all the jealousy and issues with the family that have to always be
Oh,
addressed. And
you think the other kids would be jealous if one kid got a profits interest and they didn't?
there's always the kid who feels like she's making a terrible, huge sacrifice to put up with her parents and get this company going and put up with her lazy nephews and nieces. And then there's the other kids who are jealous because she's not doing anything. She's just hanging out at the business and she's going to get the whole business. And this isn't fair at all. And this is,
Yeah.
this is why people don't have Thanksgiving with each other and with their tofu turkey.
Can we explore this a little further? If you didn't do a waterfall and you immediately gave the daughter 10% of business profits, I think you've made a taxable gift.
Right. That's right. Or or a compensation payment where the daughter takes
Yes.
his income and the company or the parents get a well, the company would get a tax deduction maybe. So it might wash out. The daughter has income and then maybe employment taxes and under Section 83, and then the parents or the company has a deduction. So it might be
So
okay. You just have to consider it.
let me ask you about that because how do you differentiate whether it's a gift or it's income? One of the things that worries me about it being immediately taxable based on the value is in this hypothetical, the daughter's actually active in the business. So how do you argue it's not compensation? But how would you I never actually thought about how do you differentiate whether it's a gift to the child or it's compensation to the child?
Well, you figure out what's best from a tax standpoint and see if you can find an expert to write a report.
Yeah, I
I,
mean, I would think you'd want to report it on a gift tax return as a non-gift item if you're treating it as compensation so that you're not also getting a gift. I think it's either gift or compensation. It can't be both. And as compensation, though, you're getting an immediate income tax deduction for the entity because it's compensation. But on the other hand, the daughter's got to pay income tax on that value.
right.
I mean,
Well,
go on.
why don't you say, I mean, if it's a big, thick situation, set up an irrevocable trust for your daughter, make it a grantor trust for income tax purposes, give it a seed capital gift, and then sell it the income interest in exchange for a note. And
So,
then
so
sell it, and then there's no income tax transaction because the trust is disregarded for income tax
I,
purposes.
I like that, and I was actually thinking about that. But then I said, if we're already going to do a grantor trust, and whether it's a gift or sale, it probably it may not matter for this purpose. I said, then why are you giving a profits interest? Why not just gift or sale or some combination of actual equity?
Yeah,
I mean,
yeah.
then you're achieve if the goal is to pass some control of the business to the child that's running it, why not give them equity, but do it in a trust so it's out of their estate, do it in a trust so you don't have an income tax problem, and the tax burden will only deplete mom's estate further.
Yeah, and a lot of times you have an S corp, and you can't really give an income interest in an S corp, so you just give part ownership to this trust. And by the way, mom and dad control who the trustee of the trust is, and if the daughter doesn't toe the line or gets divorced or who knows what, mom and dad can kind of pull the plug on distributions from that trust to the daughter, so they keep some degree of control.
I'm sure everyone understands it, Alan, but just in case, explain the second class of stock issue of the profits interest in an S corp, because that's a bad thing to trip up over. You'll ruin the S election.
Right. So most small businesses are S corporations. And the nice thing about an S corporation is the dividends that it pays out are not subject to employment taxes. But an S corporation has a very strict requirement, and that is all shareholders have to be treated equally when it comes to distributions. You
Economics broadly.
Right. Yeah, very broad economics. So you can't have preferred stock. You can't say, well, my stock will always get at least this much of a dividend, or my stock will be special from if we ever dissolve, my stock gets paid first. You cannot have capital accounts. So often we look at an operating agreement for an S corporation, and the person did it themselves on LegalZoom or wherever, or a personal injury lawyer prepares an operating agreement for an S corporation, and it says
That's a great idea.
each person will have their own capital account based on how much money they put in, and when the company dissolves, they'll get their relative contribution back. You don't have an S corporation then. You blew the S election. It's treated as a C corporation, and all those dividends you took over the years, you should have paid tax on. So that's really, really tough stuff. Now, you could have difference in voting rights. I could have 1% voting, 49% non-voting. Marty could have 50% non-voting. I can control the voting, but all distributions have to be pro rata. So that's the second class of stock rules taught in the second class of S corporation tax law.
Yeah, we've seen a lot of bad mistakes with that. And I honestly, Alan, we have to mention AI. Um, I'm going to cut off my camera because I'm seeing that my internet
It's
is a little
fine.
shaky.
It's fine.
I'm gonna.
It's really not bad, Marty. I would
Oh,
keep it on.
okay.
Yeah, it looks
Let let let,
fine and very
let
little.
let's leave
Yeah.
let's leave it off just in case.
Okay,
Um, Everyone knows how good looking I am, Alan, and they all know I'm better looking than you. So
for
I,
sure.
I can give you the limelight for a while. I'm just waiting to start to see people going not to uh, uh, the litigation attorney for an operating agreement or S corp shareholders agreement, but they're going to go online and have AI draft an agreement, and this stuff is going to be a mess. Because a layperson is not going to know the right questions to ask and has no way of knowing what sources the AI is consulting to get a shareholders agreement for an S corp. It could just be another abomination. Um, let's change gears again. And I'm not meaning to put you on the spot. And if you haven't looked at it, you're in the vast majority. But there was another proposal called something like the Fair Trust Act. And what this proposal is talking about, which certainly is not getting enacted in the current administration and current Congress, so long as the Republicans have either house, um, eh, is to assess an annual tax of 1 to, I think, 3% of the value of trust assets with trusts over 50 million. So I think it's generally being ignored by everyone because no one assumes it's going to be enacted now. And I think that's a fair statement. But I think people are missing what I really think is the writing on the wall. There's a growing desire amongst a growing number of people to create much harsher income and wealth taxes on ultra high net worth individuals and high income earners. And I don't I think it's mistaken to think this is never going to happen because it's just getting so much ground. For example, Washington State has raised its estate tax to 35%. California has a ballot proposal of a tax on billionaires, which has received a lot of press. Mayor of New York, Mondami, has talked about a $750,000 New York exemption. And while, gee, he's the mayor of the city, he's not the governor of the state. He certainly has a close working relationship with Kathy Hochul. And while I don't think 750 grand's ever going to happen, because that's probably the price in New York City of a not even a studio apartment, but we could see higher estate taxes in New York and lower exemptions there as well. There was another proposal to lower the exemption to 3.5 million. This Fair Trust Act um, talks about raising 1 to 3% of trust assets as a tax every year. So the interesting point, the proposal to reduce the exemption to 3.5 million, not inflation adjusted, which means in a decade it's going to be worth 2 million, um, is couched or framed as a way to save Social Security. We got to keep Social Security funded, and I think framing it that way makes it more palatable to people that may have otherwise rejected it. This Fair Trust Act knows that recognizes that a wealth tax violates the Constitution potentially and may not work. So they framed it, which I don't understand, and I've looked at it, but I still don't understand it, as a prepayment of future estate tax. But if you have assets in a dynasty trust, where are you going to get a future estate tax? But I think it's just the framing they're trying to do to get around the constitutional potential risk of the proposal. I think that clients need to understand, listen, the clouds are on the horizon. You shouldn't be deferring planning. I don't know that any of this stuff will permit grandfathering, but I would far prefer to have assets in an old and cold dynastic trust when the law changes than to be running in circles saying, oh my, there's a proposal and it's effective January 1 of the year. I can't even do anything. So I think clients need to be more proactive. I don't think this stuff should be ignored. Another concept, we want to draft with great flexibility because we have no idea what's going to happen with any of this stuff. So, for example, if they're going to tax trusts worth over 50 million, maybe you want provisions in trust documents to permit division. Maybe you want to give somebody, if the client's comfortable, the power to add a beneficiary to the trust, so maybe we can differentiate them. Maybe you give somebody in a non-fiduciary capacity the power to divide the trust amongst beneficiaries with out a requirement for pro rata division of assets, so they could really differentiate the trust. Now, some clients might not be comfortable with that, but I think the point I'm trying to make is these tax clouds are clearly getting darker and coming closer. Why not draft flexibly to try to address it now? Any thoughts or comments?
I think you make good points. I think that the fact that they want to tax these trusts shows how valuable these trusts are. And the constitutional issues that may prevent them from taxing these trusts are fortunate. I wouldn't I wouldn't not do trusts because they want to tax trusts. But on the other hand, there will be families that will be concerned about this tax, and they'll probably use partnerships, maybe organizations called foundations, which are not actually trusts, but are similar to trusts, private placement life insurance,
Oh,
those
but
types.
there's a bill to nail that too.
Well, there's a bill to nail that too, but the life insurance industry has a very strong lobby. So
Yeah.
I don't know that any of that would influence me to do anything different than I'm doing now, which is try to get as much of a family's wealth into estate and gift tax-free trusts as I possibly can. But maybe making sure that there's trust protectors that can pop everything out of that trust to the next generation. If the tax is on trusts only and the next generation doesn't want to pay that 3% tax, allowing that to be owned in a partnership where the older generation, generally being our clients, can control it. That might be where the answer goes. And finally letting go of these assets, these elderly folks that have done so much, that are in their late 70s, 80s, even 90s, may have to let go and let these trusts, the control of these trusts, go to the next generation. Maybe those things can at least be talked about now, and maybe this is the final thing. Okay, finally, we will give it to charity. What the heck? We've been considering charity. Maybe let's just pop it over to charity. Let's make sure that when we draft these trusts, these assets can pass to a charity. That may be preferable That allows a family to keep control of something, maybe even a charity owned business that won't be subject to all these taxes. So those things come to mind.
Yeah, I agree with you. I think getting everything in long-term robust trust makes sense. The only thing I'm contemplating is given all these different proposals, what additional measures of flexibility can we put in a trust that are palatable to a client that may, maybe not, but may give us more wiggle room to plan down the road. But I think again, so many clients are putting off planning that shouldn't, and if your estate is $25 million and we got 30 million of exemption, I don't think that's the right approach. I'd rather see some planning done now so you have an old and cold trust. It may just help significantly. Alan, I have one last topic, if you're good to talk about one last topic. So
Absolutely.
I've had a couple of prospective clients just in this past few days call where the spouse is just received a really awful cancer diagnosis. So let's just talk about what somebody with a bad health diagnosis should do, and I'll kick it off. And um, I'm going to want you to talk about basis and just planning at some point. But let's start with the basics. I think the first thing that has to be done is if somebody's got a bad diagnosis, get all their core documents in place. Will, power of attorney, revocable trust, healthcare proxy, living will. If they got a bad diagnosis, a POLST or MOLST may make sense. A POLST is physician order for life-sustaining treatment. In New York, they call it a MOLST, medical order for life-sustaining treatment. I don't know why they have a different acronym, but we the lawyers like to keep the acronyms different and complicated. But that's a document signed usually with the physician that addresses end of life decision making when somebody's terminally ill. But we should first get all those documents in place. Both of these prospective clients have documents in place, but they were done years ago. And I think once you get the stark and harsh reality of a bad diagnosis, those documents should be revisited. And I was talking to somebody this morning, one of the prospective clients, and I said, let's get this done. Let's get it off your head. You don't want your plate. You got much more important things to focus your effort on than to be worried about estate planning documents. So I think the starting point is getting the documents done. Um, Both of these clients talked to me about state level estate tax and federal estate tax. And I don't know where they got that concern from, but I reassured them both, you're married, you have an unlimited marital deduction. Yes, we can do tax planning, but don't stress over that now because it's just not relevant. And certainly we could talk about, on a state level using a family bypass or credit shelter trust to keep assets out of the estate. And that may even make sense in light of some of these tax proposals to reduce the exemption because one of them um, also talked about limiting the dessous, which is certainly it seems a little unfair because it's already out there, but maybe it pays to fund a trust. The other topic besides the core documents, which is certainly the priority, and addressing estate tax, which I think everyone on the call knows what to do. Let's talk about basis planning because that was not even on the radar of these prospects that I talked to. No one had talked to them about it. So do you want to make some comments and thoughts about that? And certainly you should explain the possibility of a jest and the 1014E rule 1 year.
Right, right. So if I have a short life expectancy and Marcia's going to hopefully live a long time, and we have assets that have appreciated in value, such as our house that may be worth 3 million that we paid 500,000 for, stock worth 3 million that we paid 1 million for, why not put that in my name or put that in a trust that can be considered as owned by me so that when I die, there's a full fair market value basis step up. Now, if we are in a community property state, that may happen anyway. If we're in California, Texas, or Arizona, one of the other community property states. But if we're in a non-community property state, which is most of the states, 42 of them, then why not put it in the name of the spouse expected to die first? But there's a 1 year rule And the 1 year rule basically says if Marcia gives it to me and she inherits it back 364 days later, there's no step up. So in that case, I could leave it to my children. Maybe that wouldn't work so well in our family if I left it to our children to avoid the 1 year rule. I could leave it on my death to a credit shelter trust for Marcia's health, education, and maintenance. But the Treasury regulations say that if I do that, it's considered to be the equivalent of leaving it back to Marcia. And while I don't think those Treasury regulations are correct, and certainly under the Loping case, you could argue,
Right.
yeah, the Loper case, you could argue that they're not valid. I don't think that works. So what
Alan, my understanding is if you left it to a Q-tip, it would be more questionable that it was equivalent to leaving back to the spouse. But if you left it in a sprinkle, not a credit shelter trust just for the spouse, but a sprinkle credit shelter trust that included spouse and children and discretionary distribution standards, and maybe you throw in another family member or charity or something as well, that there is a better argument that it's not being left back to the spouse, so
there's a
that
better
that may
argument.
work.
Yeah, but there's a private letter ruling and a TAM from 1999 and 2001 that specifically says that doesn't work. Of course, those are not precedential, but what Howard Zaritsky and I came up with was why don't you not have Marcia as the beneficiary of this trust, but appoint some friends of ours as trust protectors that could allow her to become a beneficiary if her other assets are not sufficient and she needs assets from the trust. And then on my death, get the step up, sell the assets. Uh, there's no income tax on the sale of the assets. And
Arguably.
if 5 or 6 years later she has to be added to the trust, she gets added to the trust. And that's what we do in something called the joint exempt step up trust, which is a trust that we kind of thought up, I'll say, that says when the first spouse dies, that spouse has a power of appointment exercisable in favor of creditors of his estate. And then those assets go into that credit shelter trust that the surviving spouse is not the beneficiary of unless or until trust protectors add the spouse. And that should work. That should work to get a step up. The
Do
IRS
you
hasn't
do,
approved it, but it's better than not trying.
do you think the trust approach, the just joint state step up trust, I was thinking of it in a different context. Where I've seen use of a jest is where you have spouses and you don't know who's likely to die first. Where you have a terminal diagnosis for one of the spouses, it's really a question of whether they get without that 1 year. So all the points you talked about make sense. But I wasn't thinking of the application of a jest in this context because we kind of now know, barring some freak accident, that the
Right.
ill spouse is going to die first. And it would seem like the planning that you talked about of putting the assets in the ill spouse's name for a step up, hoping that you survive for a year or longer, so you're outside of 1014E, and then making as many differences as you can bake in, and you've gone through a whole bunch of them, as far as the client's willing to go, to try to differentiate it so you're outside of 1014E if they die within a year.
Right. I just want to also mention when you have a client with that health situation, first of all, if they're estate taxable under state or federal estate tax, consider the private annuity. If the surviving spouse is going to be subject to estate tax because of the size of the assets, the private annuity numbers can apply as if they were healthy, as long as there is no one malady that has better than a 50% chance of causing death within a year. So that can be important planning to do right away and carefully. The second thing, and I tell this to the client, is please come in immediately and let me do most of what needs to be done. I would prefer that you not even leave the office until you sign what you need to sign, because too many times clients die in the middle of an estate plan, and I find that to be very upsetting for everyone. Yes, you have a 3 year life expectancy, but you're going to get upset. You're going to get sick from chemo. you're going to change your mind. And I've just lost too many clients who said, oh, yeah, I'll get back with you next week. And they never get back with us. Also, remember when an elderly person loses their spouse, they have a life expectancy issue. The first 2 or 3 years after you lose your spouse, you're in your 70s, 80s, you lose your spouse, your life expectancy is in question. So make sure that you just plan, be strong with the clients, with their children. You guys need to get this done because they say you have 3 or 4 years to live. It may
You
only be
never know.
4 weeks. You got to get this done, please. Say those words.
Yeah, and I think emotionally for the client, you've done a great good for them because this is not something that you want someone struggling in their last weeks to have to deal with. Get it off their plate.
And don't be afraid to say the death word. Say, Floyd, you don't have long. We need to get this done. Well, I don't want to talk to Mary about it. I hate talking to Mary about my death. Well, that's okay. You could talk to me about it. You don't have long. We got to get this done. It's okay to say those words.
I just had that conversation this morning and I tried to frame it a little differently. I said, listen, you can't give up hope. You never know what could happen. My father had pancreatic cancer and at age 85 had a Whipple procedure. And he was
Wow.
just one stubborn, very stubborn, tough son of a gun. You wouldn't know it from how mild mannered I am. And he lived for another 10 years after a pancreatic
Wow.
cancer diagnosis. So I told the person this because her wife had a cancer diagnosis. And I said, listen, keep hope. You never know. There's always new medical developments. But at the same hand, we have to plan for reality, which could be, God forbid, something could happen very, very soon, long before you think it will. So you should plan for both a hopeful solution and the reality, and it could be much worse and much faster than you think. Alan, I think those are some good points that we've talked about. I did a little white paper for the American Cancer Society. I'm going to post in the handouts for people to have on that, and maybe I'll post the PLR that we talked about and an article on 721. And if you have anything you want to post, we can do that. I want to thank everyone for joining me. Do you want to conclude, say any wrap up remarks or comments or thoughts?
No, but I'll send you my safety latch provision for the revocable trust, and I'll send you my savings clause for the LLC on the 721 issue.
Okay, great. We'll give a lot of materials to people. I may have to combine some of them as one PDF to put them up, but we can do that. I want to thank everyone for joining us. Alan and I have been doing this program actually every month since January. So I'm very proud. It's a long running streak for us. If you have any comments or thoughts, suggestions on topics you'd like us to do something different, we'd be happy to. The goal for this is to really have an informal discussion like Alan and I have just had and just talk about all kinds of things that we're seeing in practice that we think have practical ramifications to other people and practitioners, and hopefully that are actionable items you can actually do something with and not just ponder, the new 237th reduction on charitable contributions.
Right, right.
Okay. Thank you, Alan. Thank you, everyone. And we'll see you all next month.